Hello, everyone. My name is Samuel Spade. I am a staff attorney at Homeline, and we are going to get started here in just a few minutes. We're going to give 1 or 2 more minutes so a couple more people can join. Okay, I'm going to get started. Can we go to the next slide here?
Oh,
Thank you. All right, so what is Homeline? Homeline is a non-profit. We're a statewide organization. We provide free legal, educational, and advocacy services to Minnesota renters. Basically, if you are a residential tenant anywhere in Minnesota and you have a question about landlord-tenant law, whether it's the place that you used to rent, currently rent, or even applying for a place, you can call us or email us, and we can give you free legal advice. There are some exceptions, but it is pretty rare, and we would tell you if that happens. But we provide free confidential legal advice to residential tenants through our hotline in 4 different languages: English, Spanish, Somali, and Hmong. And we've advised over 350,000 renters since our start in 1992. If you want to contact our hotline, you can go to our website. We also have the information here. You can call us. Like I said, we have 4 different languages: English, Spanish, Somali, and Hmong, each with their own separate hotline. You can also email us in English or Spanish. Frankly, you could email us in any of those 4 languages and it would get to the right people, but we only have the form set up in English and Spanish. But these are the different ways that you can contact our hotline: by calling or by emailing us. And just a little bit of housekeeping. You should all have heard this notification, but the session is being recorded. It will be available on Homeline's website in a few days. We do have chat, and I will see it, but please ask questions through the question and answer function located at the bottom of the Zoom window. These come directly to us and won't be lost. We will be applying for 1.5 hours of CLE credits as well. And we have just a few upcoming webinars that I want to talk about. On March 18th this year, we have a webinar about Safe at Home. If you don't know what Safe at Home is, it's a program run by the state of Minnesota that protects people's addresses for a variety of different reasons. We have a presenter from Safe at Home coming to talk about how that works, and very specifically, how it works in landlord-tenant law and what landlords have to do, because of course, tenants are living at a home and not disclosing their address. And the landlord knows the tenant's address. So what goes on the lease, what goes on the tenant's mail, what goes on court cases, all of that. And then on April 22nd, again, in 2 months here, we'll be talking about terminating the lease early from the tenant's perspective, when it's acceptable, legal to break the lease early, what happens if it's not, how you negotiate out of a lease, and so on. And with that, I think that we are ready to start, and I'm going to turn it over to Maya.
Hi, everyone. Oops, sorry. My name is Maya Grimm. I am also a housing attorney at Homeline. I'm excited to be here with you all today. As you may have seen on our first slide, we're going to talk about Minnesota's landlord-tenant privacy law, what landlords' obligations are under that law, and what protections tenants have. Specifically, when we're referring to privacy in this webinar, we're talking about when a landlord enters the tenant's unit. There may be other things that come up that you think about when you hear privacy, but that is the basis for the law we're talking about today. So this is our agenda for today. First, we're going to go over just the basics of the right to privacy, what rights tenants have, and what requirements landlords have. We'll also go over some of the law's legislative history and the effects of some recent changes that were made to the statute. We'll talk about how you go about enforcing and proving violations of the privacy law in court. We're also going to go over some example cases, which will hopefully give you somewhat of an idea of how these violations play out in court sometimes. And then at the very end, we will go over some other privacy questions that we get on the hotline quite a bit that are related to privacy, but not really addressed by the statute.
And to that point, I meant to mention this earlier and I forgot, but we did get a couple of questions submitted with the registrations. We will talk about those as they come up. So, for example, we got one regarding putting up cameras, and we are going to talk about that at the very end.
Thank you. All right, so before we get in too much into the details and the weeds of the statute, we're just going to start with the very basics of the right to privacy and what its main requirements and protections are. First, landlords have to have a reasonable business purpose for entering the tenant's unit, and they have to make a good faith effort to give the tenant that reasonable notice under all of the circumstances. That notice has to be at least 24 hours in advance, and the notice has to provide a time or a window of time between the hours of 8 a.m. and 8 p.m. for when the landlord anticipates that they'll be entering. Before I get too far, you're going to hear me say a few times that some things depend on when your lease was signed. For example, the 24 hours notice and the time frame between 8 a.m. and 8 p.m., that is only a requirement for leases signed on or after January 1st, 2024. There is an older version of the law that applies to leases signed before that date. Theoretically, any lease signed before January 1st, 2024 should be pretty uncommon at this point, given that that date is over 2 years ago now. But it is possible that some leases like that still exist. So I just want to clarify, if your lease was signed before January 1st, 2024, tenants are only entitled to reasonable notice under the circumstances. It does not have to be a minimum of 24 hours, and the landlord doesn't have to provide a time frame. And we'll go over that in a little bit more detail as we move on. Secondly, there are exceptions to the notice requirement. There are situations where landlords do not have to give advance notice to tenants that they will be entering. The privacy law is governed by Minnesota statute, or the privacy law is Minnesota statute 504B.211, which you can see there on the screen. And notably, the requirements of the privacy law cannot be waived in the lease or otherwise. So anything in the privacy law does need to be strictly followed by landlords and tenants as well. I just want to point out, you're going to hear me refer almost exclusively to landlords throughout this presentation. The law explicitly refers to landlords, but it does also apply when any person acting under the landlord's direction or control enters the tenant's unit. So this can include maintenance people, property managers, anybody who's entering because the landlord owner told them to. So it doesn't exclusively apply to only the landlord owner, just so we get that out there now. This law also only applies when the landlord is entering the tenant's rented premises or their actual unit. So if you're in an apartment building, landlords don't have to give notice or follow these requirements if they're going into common areas, for example. And also the privacy law does not apply to landlords and tenants of manufactured home parks. So if you are a landlord or tenant, if you are a tenant who has questions about privacy in a manufactured home, feel free to contact our hotline. You can also drop questions in the chat. All right. So moving on to the first basic tenet of the privacy law. Landlords must have a reasonable business purpose to enter the tenant's unit. The statute 504B.211 gives 9 examples of what a reasonable business purpose is. That can include showing the unit to a prospective tenant when the current renter has given their notice that they're moving out. If the tenant is causing a disturbance in the unit or violating their lease, that's a valid, reasonable business purpose. The most common one we get questions about on the hotline is when landlords are entering to do repairs or maintenance, which is also a reasonable business purpose. So those are just some examples. Allowing inspections by state or city government, as you see on the screen, is also a reasonable business purpose. The landlord's not limited to only those purposes that are listed out in the statute. It's not an exhaustive list, so there could be other valid reasons for entering that aren't listed in the law. But the reasonable business purpose just has to reasonably relate in some way to the landlord's interest in the property. If you have specific questions about whether something is a reasonable business purpose or not that's not listed in the statute, feel free to ask questions about that. Now I've given some examples of what are reasonable business purposes. You might be asking what is not a reasonable business purpose. One example of that could be where the landlord wants to enter to assess the unit for damages relating to the security deposit in the middle of a lease. This would not be a reasonable business purpose because assessing a unit for damages should be done at the end of the lease, not in the middle. So that is one example. And I also want to talk a little bit about the scope of the reasonable business purpose. It is possible for a landlord to give proper notice, have a valid reasonable business purpose to enter, and they can still violate the law by exceeding the scope of the reasonable business purpose. Whatever reasonable business purpose that's given for the entry, the landlord's entry should be limited to entering for that purpose. So, for example, if the landlord is entering to do a repair in the tenant's kitchen, I can't think of what a valid reason would be for them to be in the tenant's bedroom that's on the other side of it. That's just an example. Now that doesn't mean that the landlord is necessarily strictly limited to only observing or doing what the reasonable business purpose was. For example, the landlord enters to do a repair in the kitchen and they can see from the kitchen that there's some sort of breach of lease. Maybe there's cigarette butts on the table in a non-smoking building. Landlords can take note of that, but landlords generally should not be wandering around the tenant's unit looking for things that are unrelated to the reasonable business purpose that they originally gave for the entry. So that is the basics of having a reasonable business purpose. Second, the tenant has
Do you
the
mind
right.
if I jump in quickly with the
No, go
question?
for it.
One
Yeah.
of the questions that we get asked a lot on the hotline is about inspections. And, I think you said that a landlord can come in to do inspections. It's one of the things allowed by the statute. But how often is a landlord allowed to come in and do inspections? Like, do you think there are any limits on that?
I think it depends on what the inspection is for. And Samuel, you might actually have more insight onto this. If for example, oftentimes if a tenant or I guess a landlord contacts a city inspector, they come out and do an inspection. Sometimes they need to come out a couple weeks later to re-inspect the place. Things like that are probably fine and fit into a reasonable business purpose. In fact, they almost certainly are. But if your landlord is doing inspections once a month, once every other month, for no real stated reason other than just to assess the state of the unit, I would think that that's somewhat questionable. Samuel, do you have other thoughts on that?
No, I would completely agree. I mean, the standard, like you said, is a reasonable business purpose. So an inspection is a reasonable business purpose, but you can certainly imagine too many inspections, like daily inspections. That's not reasonable, at least not without some very extreme circumstances. Um, so at what point, like, where's the line? Is like daily too much, once a year, perfectly fine. A lot of it just depends, I would say, on the facts. But I think, as you said, like if you are weekly or monthly or like those types of things, that's not reasonable anymore. So the tenant can start refusing.
Yeah. Okay. And then second, along with needing to have that reasonable business purpose, tenants are also entitled to advance notice of the landlord's entry. The notice needs to be reasonable notice under all the circumstances, and the landlord has to make a good faith effort to actually give tenants that notice. We'll go over an example in the next slide, which covers the good faith effort part of that, which will hopefully provide some clarification. Um, all tenants, regardless of what date the lease was signed, are entitled to reasonable notice under the circumstances. And that under the circumstances is really referring back to the reasonable business purpose. So tenants should ask themselves, was the amount of notice I was given reasonable in light of what the landlord is entering to do? And we'll go over an example which should also provide some clarification on that. So, on top of there needing to be reasonable notice under the circumstances and making a good faith effort on the landlord's part to give that notice, if your lease was signed on or after January 1st, 2024, then the tenant is also entitled to at least 24 hours notice on top of it being a reasonable amount of notice. The tenant can decide in any of these situations to let the landlord in without proper notice if they want to, but they do not have to. So, along with that reasonable notice, and then if your lease was signed after January 1st, 2024, has to be a minimum of 24 hours. Again, if your lease was signed on or after January 1st, 2024, then the landlord also has to give a specific time or a window of time for when they anticipate they'll be entering. That time or window of time has to be between 8 a.m. and 8 p.m., and that can be on any day of the week.
And I just want to jump in to add a comment about something you said with the tenants being allowed to let the landlord in. When I was part of the group that was pushing for the change in the statute that you're going to talk about in a few slides, and that was something we added to the statute because landlords really wanted it, but that's always been the case.
Yeah.
Tenants have control of their unit. If they want to let someone in, they can always let someone in. And often we get that sort of complaint or fear from landlords, which is, well, the tenant said they want this done. And I could go over now and do it, but I can't get like it's only 5 hours, away that I would be there. That's not 24 hours notice. And the answer to that is always, I mean, just ask the tenant, see if they are okay with it. If the tenant wants the repair done quickly, the tenant will probably give permission. It's the tenant's unit in the sense that they're renting it. They have possessing rights. They can say, all right, you can come in. So if the landlord wants to come in with less than 24 hours notice, especially in the case of a repair or something that the tenant has requested, they can always ask for permission to enter early. Then the tenant can always provide it if they want to. These are the rules that establish when the landlord can effectively enter over the tenant's objection or without the tenant's permission. When the landlord can say, all right, we're giving notice, we're coming in. Then they have to follow these rules. If the tenant is willing to give permission or the landlord can get the permission from the tenant, then they can enter.
Yeah, thank you for clarifying that. And this might lead into a question of can I, meaning a tenant, be home when the landlord enters? Tenants don't have the right to be there when the landlord enters, but they can be. There's nothing in the privacy law which would allow the landlord to force a tenant to leave while they enter their unit. However, on the flip side of that, tenants don't have a right to be present when the landlord enters. So tenants cannot require a landlord to come only when they're at home, and tenants cannot force landlords to come just at a certain time just because they want to be home. The landlord can enter at any time so long as they have that reasonable business purpose and proper notice was given, and if it's in between 8 a.m. and 8 p.m. So the tenant does not have the right to be present when the landlord enters, but they most certainly can be. So just to recap quickly what we've covered so far, the landlord has to have a reasonable business purpose that justifies the entry. They have to give the tenant advance notice, the amount of which has to be reasonable in light of whatever the reasonable business purpose is. And if your lease was signed on or after January 1st, 2024, it has to be a minimum of 24 hours notice, and the landlord has to give a time frame between 8 a.m. and 8 p.m. for the entry. And now we'll go over some examples of what is a bad notice. The first one's pretty obvious. Landlord gives the tenant a short notice. So if a landlord gives the tenant a notice that they will be entering in 30 minutes for a non-emergency issue, that's certainly not valid notice, probably regardless of when your lease was signed. It's not 24 hours notice. So if your lease was signed on or after January 1, 2024, this is definitely not valid notice, and almost certainly wouldn't be considered reasonable notice either. I can't imagine a reason that's not an emergency that a landlord would need to enter in 30 minutes notice. And if it was an emergency issue, that actually means the landlord doesn't have to give any notice at all. So a 30-minute notice, almost certainly invalid no matter where or when your lease was signed. Now, let's say the landlord gives the tenant a blanket notice. So that a landlord gives a notice this week and says, we're going to be coming by sometime next week or sometime over these 4 days, sometime between 8 a.m. and 8 p.m. Technically, this complies with the law since it's at least 24 hours notice and almost in reasonable notice, in the example I gave, since we're talking about basically a week's notice, and the landlord did give a time frame for entry. So technically, it complies with the language of the law. However, I would argue that notices like this are not valid because they don't comply with the purpose of the law, which is to give tenants enough time to plan to have the landlord in their unit. And if a notice says that a landlord will be entering on one of these 4 days, then that really doesn't give the tenant the ability to plan for the landlord's entry because it's just one of 4 days and who knows when they will actually enter. I'm not aware of any cases that have litigated this type of blanket notice issue, but there's definitely an argument that these types of notices are not valid.
And I'm just jumping on to say, Maya and I were talking about that exact question of, are there any cases that are litigated or that have been litigated about this issue? And I'm not aware of any either. And I have looked at a fair amount of rent escrows. But we've got some attorneys on this call. We've got a number of them. And if you are aware of any, I'd be happy to hear about it. Send me or Maya an email. And yeah, because Homeline's position, what Maya said is, effectively, the notice isn't reasonable. It doesn't actually let the tenant plan for their life. When do they shower? When do they take a nap? When do they eat? When do they do anything if the landlord has said, I'm going to come in? And, it's a bit extreme, but if that's allowed, why not just give a month-long notice? Why not give a year-long notice? And then you get entirely out of this notice requirement. There's obviously some limitations. And in general, a day, that window of 8 a.m. to 8 p.m. is what we would say is the reasonable notice sort of built into the statute. Maybe in some extreme situations, landlords could argue for slightly more time, but again, once you go to like a week or something like that, it's just hard to see a judge upholding that. And so the tenant could refuse entry, and as Maya will talk about later, even sue for privacy violations.
Okay, and then this third example. Some landlords think that when a tenant puts in a maintenance request or a repair request, either through a portal or otherwise, that automatically is giving the landlord permission to enter to do that repair or that maintenance. I've seen leases that even say that putting in a maintenance request gives the landlord permission to go ahead and enter whenever to do the repair. As I mentioned before, the requirements of this privacy law cannot be waived by a lease or anything else. So putting in a maintenance request does not give the landlord the right to enter whenever they choose. They still have to give advance notice of that entry. It has to be reasonable and might have to be 24 hours notice and give a time frame if your lease was signed after January 1, 2024. And then this one is a little bit more of a gray area, and I'm hoping this will help clarify specifically for leases signed before January 1, 2024. Hopefully this will help provide some context in determining what is reasonable notice, since that is a little bit vague and can be hard to decipher. So in this example, let's say the landlord gives a notice to the tenant saying they will enter in 3 hours. If the lease was signed on or after January 1, 2024, then this isn't a valid notice because it's not at least 24 hours in advance. But if your lease was signed before that date, this could be reasonable notice, but it would depend on what the reasonable business purpose is that the landlord is entering for and what all the circumstances are surrounding that. So let's say that the tenant's bathroom faucet doesn't have water coming out, but there's still running water in the rest of the unit, so it's not an emergency. In that case, 3 hours notice might be reasonable in light of the issue because though it's not an emergency issue, one, it could cause more problems if the landlord doesn't address it relatively quickly. And two, kind of like Samuel mentioned already, most tenants generally have an interest in getting things like this fixed sooner rather than later. But in that kind of same type of scenario, if the landlord gave 3 hours notice to do a showing to a prospective buyer or a prospective tenant, that is probably not reasonable notice under the circumstances because one, usually a landlord would know about a showing more than 3 hours in advance. And two, showings are typically not time sensitive. So landlords could have relatively easily scheduled a showing at a time which would have allowed them to give the tenant more notice than 3 hours. And another difference between these repair and showing examples is that a tenant doesn't really need to prepare in the same way to have a repair done. But when doing a showing, a tenant would probably want to have enough time to clean up, put away any personal or private items that they don't want strangers to see, and things like that. So that's kind of an example of determining what is reasonable under the circumstances. Samuel, you might have something to add to that.
No, well, I guess I could, but I was actually just showing up to say that we do have a question, and I wanted to say that we see it, and we're going to answer that question in just a few slides. And then to answer your question, yeah, I mean, I would say obviously, as you said, that this applies, 3 hours is less than 24. So it's not leases that were signed after or on January 1st. But
Mhm.
otherwise, I think pretty much exactly what you said is correct. And, especially with regards to showings, it's probably worth adding that tenants don't need to do anything to prepare for a showing. Like they don't have to clean, but most tenants are going to want to. And I think your point that that means more notice is going to be reasonable
Yeah.
is a good one.
And some leases, I've seen leases that actually like will require like that the tenant needs to clean to do a showing or like pick up and things like that. And if, especially if that is required by your lease, then you definitely need more than 3 hours notice to prepare for that and comply with what your lease says. So, and then this last example is dealing with the good faith effort part of the notice requirement. Like I said before, landlords have to make a good faith effort to give the tenants advance notice of their entry. So let's say a landlord gives their notice of the entry, and the only way they give it is by taping it to the tenant's front door. But the landlord knows that the tenant is out of town on vacation. In that scenario, the landlord did not make a good faith effort to give the tenant notice because they should have known that leaving a physical notice taped on a tenant's door was not going to reach them when the tenant is out of town on vacation. Um, so this might bring up a question like, well, if the landlord knows that the tenant isn't going to be home, do they still even need to give notice? And the answer is yes, they do still need to give notice.
And we do have another question here, which relates exactly to this, so I'm going to ask it. But are there any specific requirements for a landlord giving notice, such as via written notice on the door or text or email? Also, if conducting unit inspections for the whole building, can notices be placed in multiple locations in the common areas, entrances, exits, or do they need to be on each individual unit door? And so two questions there, but first part I think is just what type of notice? How does the landlord have to give notice? Are there any requirements?
So the actual statute doesn't have a requirement for like method of delivery of these types of notices. It kind of gets covered by the good faith effort part. Typically, if it's best to just for landlords to give notice in a way that they typically communicate with their tenants. So if they regularly communicate with their tenants via text, sending a text message as notice is probably okay. If they regularly communicate via email, that's probably okay. Um, I think Samuel and I kind of had a discussion the other day about, well, what happens if a tenant never checks their email or never listens to their voicemails, and that's how the tenant or how the landlord gave their notice. And there is some argument that if the landlord were for some reason to know that you never check your emails, then maybe that's not a good faith effort on their part to give you notice. But the law doesn't actually require it in any certain format. Um, yeah. Samuel, you probably have other thoughts on that, maybe?
No, I would say that I think that that's pretty much exactly it. It's a good faith effort. I mean, the definition of that in layman's terms is just that you tried, and you tried in a way that you thought would be effective. So the example that Maya gave of, leaving a physical note when you know they're on vacation, clearly that's not going to be effective. They're not going to get it. And then, the second example that she gave where, not the tenants not listening to the voicemails or the emails. Um, if you know that the tenant doesn't do that, then I think as a landlord or a landlord's attorney, that's not a good faith effort. But if the tenant responds, clearly it worked. And if the tenant sees it or those types of things, a lot of messaging apps have that, it works. And you don't just have to give it in one way either. You can give it in multiple ways. And so, to answer the question about like uh, putting it on the individual unit's door and common areas, probably the answer is that the common areas is not enough. That's not likely to be good faith unless the landlord has some specific knowledge that everybody goes and checks it or something like that. But in general, I would say that I at least get calls pretty regularly where the tenant did not get that type of notice because they did not see the bulletin board. They did not see it on their door. Like, you can't assume that people are even leaving their apartment every day. Uh, Tenants might be at home for several days without leaving if they work remotely or they don't work, retire, whatever. Um, so, I think that good faith effort means you're giving each individual tenant notice in a way that they are likely to receive it. And, you know, the, that's the bare minimum. Tenant landlords can definitely go above and beyond that to give notice in multiple ways: email, text, posting in common areas, etc., and that type of thing.
Yeah, I think also just best practice if for landlord's attorney, if you're worried that the tenant hasn't received notice or they didn't get it, sending it multiple ways is always a good idea just to kind of try and cover all your bases and do your best to make sure that the tenants are actually receiving that notice. Okay, and the third kind of basic requirement of the privacy law is talking about emergencies. There are situations in which landlords can enter a tenant's unit without giving them any notice at all. There are only three reasons that a landlord can lawfully do that, and they are laid out in the statute. Unlike the list of reasonable business purposes that we talked about, that is not an exhaustive list, so there could be other valid, reasonable business purposes. For the emergencies, this is an exhaustive list. So these are the only three reasons that a landlord can lawfully enter a tenant's unit without giving them any advance notice. The first reason is where immediate entry is necessary to prevent injury to persons or property relating to maintenance, building security, or law enforcement. So an example of that would be where the landlord enters to do some sort of emergency repair. Like if the heat is out in the middle of winter or a pipe burst, something like that, the landlord wouldn't have to give notice before entering to do the repair. The second emergency reason is where immediate entry is necessary to determine a tenant's safety. So, like doing a wellness check. And then the last emergency reason is where immediate entry is necessary to comply with local ordinances regarding unlawful activity that's occurring in the tenant's unit. And there is a little bit of an extra step. So even though for these three reasons, landlords don't have to give advance notice of their entry. If they come in for an emergency reason, meaning no notice was given to the tenant, no advance notice, and the tenant isn't home when the landlord comes in for that emergency reason, the landlord has to leave a note letting the tenant know that they were there, and they have to leave that note in a place in the unit where the tenant is going to see it. So that's just really an effort to make sure, like, if landlords are coming in with no notice, that the tenant still has some knowledge that somebody was there.
And I just want to jump in for perhaps a little bit of color commentary in the third point of complying with local ordinances regarding unlawful activity. This language is a part of the original statute, which was many years ago. In the nearly 20 years I've been doing this now, I don't think I've ever seen this. And I honestly have trouble even thinking about what it is. It is like it's pretty specific, complying with local ordinances regarding unlawful activity. And as we'll discuss briefly at the end here, I mean, this does not give landlords permission to let the police in, for example, without a warrant or anything like that. So I've never seen this one come up. Uh, Again, in all the time, maybe if there's a landlord's attorney out there who knows of an example or wants to put forward an example, that would be interesting to hear. But I've never seen come up. Generally, when we're talking about emergencies, you're talking about, as Maya said, preventing injury to people or property. The landlord thinks that if they don't go in, somebody's going to get hurt or is getting hurt, or the property is going to be damaged in some way.
Yeah, that last one, which is why I didn't have I had an example for the first two and not the third one, because I actually cannot think of one either. It's a little bit odd and kind of niche, but yeah, mostly coming in to prevent injury to the tenants or the people living there, and then the landlord's actual property. And again, just if the tenant or the landlord enters the home for an emergency, no notice, then they have to leave a note if the tenant was not home to let them know that they were there.
And then we've got two questions about the consequences, which is the very next slide.
Yes, we will move on to the penalties. So this is the last kind of main point of the privacy statute. There are penalties for landlords who violate this law. The tenant can get money for the privacy violations, the amount of which does vary depending on when your lease was signed. If your lease was signed before January 1, 2024, it's only $100 per violation. And yeah, just to reiterate, it is per privacy violation. So if there are multiple, you can get $100 per however many violations. If the lease was signed on or after January 1st, 2024, then the penalty is $500 per violation. The statute also authorizes a penalty of up to full rescission of the lease, meaning that's just a fancy way of saying that tenants can have the court terminate their lease early, actually, for these privacy violations. So if a tenant's privacy has been violated and they don't want to keep living there under that landlord that violated their privacy, they can actually get out of their lease early by asking the court to terminate it so that they can move elsewhere. And if a court does terminate a tenant's lease early, they are entitled to have their security deposit returned to them. The tenant can also get rent abatement, which is just a discount in rent. Usually we see this happen in the form of the court awarding a discount in rent for the month or months in which a privacy violation occurred. I think it's off. This Samuel may want to jump in here. We have seen tenants get like 100% discount for the month of rent, so that month is free. The court can either order the landlord to reimburse the tenant for that month's rent, or just say don't pay next month's rent, and that will equal it out. I don't think and maybe Samuel, you have seen this. I don't think a court has ever awarded like 50% rent abatement for a month. I think it's usually more of an all or nothing thing, but
Yeah, that's certainly what I've seen. And we'll see this when we talk about some of the example cases at the end here. But normally, the tenant either gets like the penalties, the 500 or the 100, depending upon when, and nothing else, or the judge hits the landlord with everything. Like the tenant is getting penalties for each violation, full rent lease is terminated, full rent abatement in at least the final month. The security deposits returned. The tenant is getting attorney's fees. Because tenants really care about privacy violations, and courts do too. Often, if they're substantial enough, they care a lot. And so, again, but that's sort of the thing is it's either okay, landlord, you violated, here are the penalties, or landlord, you really violated. Everything the tenant asked for is happening. You're getting hit with all of these penalties.
yeah. And then very last penalty, the tenant can also be awarded reasonable attorney's fees if they hire an attorney to represent them in the lawsuit and win the case. However, these attorney's fees are only made available by the statute, by the privacy law, if the lease was signed on or after January 1st, 2024. If your lease was signed before that date, tenants may still be able to get attorney's fees. It would just depend on what the lease says, if it says anything about attorney's fees. So it is possible to get attorney's fees if your lease was signed before January 1st, 2024. Actually, one of the cases we'll look at, they did get attorney's fees, and it was under this older version of the statute. But for leases signed on or after January 1, 2024, tenants are entitled to reasonable attorney's fees if they win the privacy lawsuit. So that is the end of the basics of the privacy law, the reasonable business purpose, reasonable notice, penalties, and then also entering for emergencies. Now we will move on to, and I'm going to talk a little bit about the legislative history of the tenant privacy law, how it's changed over the years, and how we got to where it is today. Really, the general layout of the law hasn't changed all that much since it was originally enacted in 1995. There was one major amendment to the privacy law, which you kind of already heard me talk about, that passed in 2023, and those changes that were made only apply to leases signed on or after January 1st, 2024. And that's part of why I go over this history too, is just to clarify that there is an older version of the law that could potentially still apply. Like I said, I would think those leases are becoming less and less common, and at some point it will probably become irrelevant. But for now, those leases could still exist. But the law was originally Minnesota Statute 504.183, and as I said, it was enacted in 1995. There was a very slight modification to the law in 1996. All that did was add an additional reasonable business purpose to subdivision 3. So it wasn't a substantive change. Then in 1999, all of the landlord tenant laws were recodified into Chapter 504B. So they were all in this one chapter in the same place. That is when the privacy law became the statute that you've already seen, Minnesota Statute 504B.211, and that is still the correct citation today. The main purpose of enacting a tenant privacy law in the first place was to give tenants time to prepare for a landlord's entry into their home. Some people, though this wouldn't have been very relevant in 1995, nowadays in this post-COVID era, lots of people work from home. And so they need to make plans for the workday if the landlord's going to be there during the day doing a noisy repair or something like that. Some people have pets or children that they need to make arrangements for if the landlord's going to be there. Tenants may want to clean up or put away private information before the landlord enters. I have heard of a situation where a landlord came in without giving any notice. The tenant wasn't home and the tenant had financial documents sitting out on their counter. And obviously, that is information that most people would not want others to see, especially when they're not home. So when a tenant rents, it's obviously understood that they are renting property that somebody else owns. But ultimately, that rented property is the tenant's home, and everyone deserves some degree of privacy in their home. And so that was kind of the mindset behind enacting the privacy law in the first place. And now we will go over the privacy law as it's currently written, really focusing on the changes that the amendment made in 2023. The main issue with the older version of 504B.211 is that its language is vague in a few areas, like the reasonable notice leaves open a lot of interpretation as to what is reasonable. The penalties under the old version of the statute, the landlord had to substantially violate subdivision 2 to get the penalties. So there were just a few things in there that gave courts a lot of discretion in deciding whether there was a violation and whether or not to award the penalties. The 2023 amendment made 5 substantial changes, and through that amendment, we were able to get a lot of that vague language clarified and just made more clear. We were able to make a lot of these changes in 2023 by showing research on other states' privacy laws. That research was done in 2022, ahead of when the amendment was proposed, so it could be a little bit outdated now, but at that time, 82% of US states required landlords to give some sort of notice before a landlord entered a tenant's unit. And conversely, only 18% of the states at that time had no notice requirement at all. 58% of states at that time required that tenants get at least 24 to 48 hours notice. So showing that this is a very common practice among the states really helped to show that Minnesota needed to catch up to the majority of the country and clarify that at least 24 hours notice is required. So before we talked about how the landlord needs to provide reasonable notice and how vague that language can be. Now, this has been clarified so that it's reasonable notice and at least 24 hours notice before entering the premises. Again, tenant can always agree to let a landlord in with less than 24 hours notice, but they don't have to. The second change is along with reasonable notice and a minimum of 24 hours, the landlord has to include in their notice when they're going to be entering. That's providing a specific time or a window of time between 8 a.m. and 8 p.m. And again, that can be on any day of the week. The third major change was to subdivision 6, which is where it talks about the penalties. In the older version of the statute, I kind of mentioned this already, if the landlord violated the reasonable notice and the reasonable business purpose requirements, it had to be substantially violated in order for the tenant to get the penalties. And obviously that language, the substantially violates, gave the court quite a bit of discretion in deciding what happens when there is a substantial violation. The older version authorized a penalty for a substantial violation of subdivision 2, which is that reasonable notice and reasonable business purpose requirement, and also any violation of subdivision 5, which is where it talks about landlords needing to leave a note if they come in for an emergency and the tenant isn't home. We were able to clarify all of this through the 2023 amendment and just make it a bit more black and white. Now, the penalty, the $500 penalty, lease rescission, rent abatement, all of that is available for any violation of any subdivision of the statute. So if 504B.211 is violated at all, those penalties are now available if your lease was signed on or after January 1st, 2024.
Yeah, and then I just want to jump in here to stress before you move on to the next section that it is still reasonable notice plus a minimum of 24 hours
Yes.
notice. So 24 hours notice is the minimum, but there are certain cases where it might need to be more notice than 24 hours because reasonable notice might be longer than 24 hours. An example would be if the landlord is going to do work on the tenant's only bathroom. Maybe 24 hours notice is not sufficient for that because the tenant will be without a bathroom for a full day. And you can think of other examples as well where the entry is going to be so substantial, so disruptive that it is unreasonable to give just 24 hours notice and the landlord actually needs to give more. 24 hours is just like it can never go below that. But there are cases where it might still need to be more under both the old and the new version of the statute.
Yeah. Yeah, thank you for clarifying that. It's for all tenants. Doesn't matter when your lease was signed. You are entitled to reasonable notice, whatever reasonable it means in the context of whatever the landlord is entering for. It's just that if your lease was signed on or after January 1st, 2024, it cannot be less than 24 hours notice. Thank you for clarifying that.
We also have
Um,
if you don't mind, we have a
yeah.
question here which I'll answer as I was part of the group again that worked on changing the law. But it's why was it necessary to eliminate the court's ability to use its discretion and make the penalties required? So there's a couple of answers to that. First, the court in that one sense didn't have discretion before. If it was a substantial violation, they needed to give it. It just changed the standard. But I think to the core part of the question is we and tenants and just in general wanted clarity because there is confusion and we'll actually when we get to some of the example cases all of which were actually under the older version of the law that required substantial violation we can talk about this but there's confusion on everyone's part. There's confusion on the tenant's part, there's confusion on the landlord's part, there's confusion on the judge's part. Having a clear line where it's just if you violate this, these are the penalties is helpful in making the standard available and understandable to everyone. And again, there are different things that a judge can order. So there is still discretion on the judge's part to order different things. It just makes the standard clear.
Sorry, lost my train of thought there for a second. Still talking about the penalties. The fourth major change that was made was the penalty was up from $100 to $500 per violation. This was a pretty big win for tenants for a couple of reasons. One, a $400 increase is not particularly small. That's a lot of money for a lot of people. And two, upping the penalty provided more incentive for landlords to actually follow the law. For a lot of landlords, specifically larger ones like property management companies or something like that, $100 is just relatively nothing in the grand scheme of things. So there was more risk of landlords being willing to violate the law because there just wasn't enough incentive for them to follow it. And it also gives tenants a better reason to actually enforce the law in court. To file a lawsuit for a privacy violation, the tenant is going to have to pay a filing fee of around $80 to file the case, unless they're low income enough to qualify for a fee waiver. So, for a lot of tenants, if we're talking about just a single privacy violation, $100 just wasn't worth the extra time and effort and money that they'd have to go or they'd have to put into filing a lawsuit for the violation.
And I want to jump in. As Maya said, the statute existed basically without change since it started in 1995, and that $100 was in 1995 as well. So,
Yeah.
Google says that the inflation rate that would be about $215 now. So it is still an increase, but some of it was just to account for inflation and the change in value over the last 20 years.
Yeah, absolutely. And then the last major change, though this may seem maybe inconsequential just from reading it, but the amendment made a violation of the privacy law also a violation of 504B.161, which are the landlord's covenants of habitability. Talks about landlords' obligations to keep the premises fit for the use intended by making repairs, providing heat, pest control, things like that. And this seemingly minor change actually has big implications specifically for eviction filings, which we will actually discuss in the next slide. And I'll pause for a second to see if we have any questions about these changes from the amendment. If not, we'll go ahead and move on.
No questions right now
Okay.
beyond what we've answered.
Okay. And on that last change I was talking about, is using privacy violations as a defense to evictions, specifically evictions for non-payment. If it's a breach of lease eviction, this is not going to apply, but for evictions for non-payment, privacy violations can now be used as a defense. The Minnesota Supreme Court has held that there are only two affirmative defenses to evictions. The first is a breach of the covenants of habitability, which is that 504B.161 that I mentioned. And the second is if the eviction was filed in retaliation. Not going to get into the retaliation defense today, obviously. There is a statute 504B.285. If you want to read up on that, go ahead. But because the recent amendment to the privacy law explicitly made a violation of the privacy law a violation of the covenants of habitability, tenants can now use privacy violations to defend against evictions for non-payment of rent. When a tenant is defending against an eviction based on the landlord's breach of the covenants of habitability, this is often referred to as a Fritz defense. It was established in that case. You can see in the second bullet, Fritz v. Wartherm. The gist of that defense is that though the landlord has filed an eviction for non-payment of rent, the tenant is arguing that some or all of that rent is not owed and was withheld because of the landlord's violations of the covenants of habitability. Before this amendment to the privacy law, this mostly came up with repair issues. If a landlord filed an eviction for non-payment of rent, but the tenant had been dealing with chronic repair issues, and so they'd been withholding rent. That's the way we most commonly saw a Fritz defense used, but now it can be used for privacy violations as well. Now, up until the 2023 amendment, multiple courts had held that violations of the privacy statute could not be used as an offense to an eviction. One of those cases is this Owen v. Johnson case that you see on the screen. That's a Minnesota Court of Appeals case from 2023, but that's just an example. There were many courts who decided that. Now, again, violations of the privacy law can be used as a Fritz defense to evictions for non-payment of rent. So it can either in a successful Fritz defense, it can either lessen the amount that the landlord claims was unpaid by the tenant, or possibly in some situations could negate the whole amount that the landlord says they owe. Just kind of depends on what the details of the eviction were. Since this amendment is so relatively new, we've not actually seen anyone try a Fritz defense for a privacy violation that I know of. If you are an attorney watching this and you've seen this argument play out in court, we would love to hear from you and just hear about how that went. So feel free to email Samuel or I. Like I said, we'd love to hear from you. If you have questions about using a Fritz defense in an eviction case, probably best to contact Homeline's hotline and we can help you more specifically there.
All right, so we do have a question, which if you don't mind, I'll try to answer here live. But it is, can you explain in more detail how a tenant would use this defense under 504B.161? And so, as Maya said, the Fritz defense is effectively, there was a violation of the covenants of habitability, so some part of rent is not owed. So the landlord, or most classically, there's a repair issue. The landlord's not making a repair. The tenant withholds rent because of the repair. They go in front of a judge. The judge holds a trial, and if the tenant proves that there is a repair issue, the judge reduces the rent by some amount, maybe even to zero. And if any rent is left owing after that, the tenant would pay it and continue to live there. The same thing can now be done with the privacy statute. The tenant would assert that it's a violation of the covenants of habitability, that the rent therefore should be lowered. The privacy statute itself has, the monetary damages of $500 per violation, but it also says that rent can be reduced. And as we will talk about in a few slides here when we go over some of the privacy cases that tenants have taken and won, judges do often reduce the rent, sometimes even all the way to zero. Or, actually, as we discussed, if they reduce the rent, it's almost always all the way to zero. So the tenant could argue in an eviction case that the rent that they owe is nothing, or reduced by the $500 penalty because of the privacy violations. And again, we have not seen one of these cases yet. This is a fairly recent change. Uh, there might very well have been cases like this at the district court level. You often don't see those cases unless you're a part of them. So, a legal aid attorney or an attorney for a landlord might see one of these. But unless you're actually involved in the case, you won't know. There's really no way to search them unless they go to the Court of Appeals, and that has not happened yet. So if you know of any cases like this, as Maya said, we would love to hear about it. And then we have one more question. Would tenant be required to escrow with the court the sum they claim is not owed to the landlord? We'll talk a bit more about that when we talk about the like filing a rent escrow, which Maya will cover in a few slides. But with the eviction case, using it as a Fritz defense, the answer is no. Due to a change in the law, not the same change in the law, but part of that whole package in 2024, tenants no longer have to escrow any rent, even for a Fritz defense, uh, when they are having an eviction trial. Now, if the trial is going to last more than 10 days, the judge can have a bond or require the tenant to post a bond that is up to the amount of ongoing rent. So in a case like this, if the tenant was going to raise a Fritz defense using privacy, and the trial was going to take more than 10 days, they might have to post a bond. That would be up to the judge, but they might have to post the bond, which at max could be equal to ongoing rent. So as it becomes due, but they wouldn't have to escrow the required sum for privacy or for any other issue, like a repair or Fritz case.
All right. So now, if you're a tenant and you've determined that there has been a privacy violation or you think that there has been one, the next question is usually like, how do I go about enforcing the law and getting the penalties that I'm entitled to? There are two basic options depending on whether the tenant has moved or not. More specifically, depending on whether the tenant is still a tenant of the landlord who violated their privacy. If the tenant has already moved out and has no landlord-tenant relationship with the landlord who violated their privacy anymore, then the option is to file in conciliation court, also known as small claims court. If the tenant is still a tenant of the landlord who violated their privacy and they haven't moved out, they can file in conciliation court still, or they can file a rent escrow action. The rent escrow is only an option if the tenant is still a tenant of the landlord who violated their privacy, because there has to be an ongoing landlord-tenant relationship to file a rent escrow.
I do just want to clarify it's to file a rent escrow. Cases can continue, and in fact, we're going to look at one, I believe, that did start as a rent escrow that continued after the tenant stopped being a tenant. But the key standard is when they filed, were they a tenant? So long as they were a tenant when they filed, it's appropriate. But a former tenant cannot file a rent escrow.
Yes. Thank you for that clarification. Okay, so filing in conciliation court. This, like I said, whether or not the tenant has moved or not, conciliation court is an option. It's just that if the tenant is still living there, rent escrow is probably the better option because it's a lot faster, or you're going to get a hearing a lot faster than conciliation court typically. So if the tenant's lease has ended or the landlord has violated their privacy, they can sue in conciliation court. Small claims court. One thing to consider when filing in conciliation court, for a privacy violation, you can ask for all the penalties that we already talked about, the $100 or $500 per violation, rent reduction, return of the security deposit, things like that. But if you're filing after you've moved out, you meaning a tenant, if a tenant is filing after they've moved out, we recommend waiting to see what the landlord does with the security deposit. Landlords are required by state law to return security deposits within 21 days of the lease ending and the tenant providing their forwarding address. So typically, we'd recommend waiting the 21 days to see if the tenant receives their security deposit back, because if they don't, or they do, but the landlord withheld part of it or all of it, and the tenant doesn't agree with that withholding, the tenant can file a case in conciliation court for both the privacy and security deposit issues, which just saves everybody time and money for the most part if you can do multiple issues in one case. And as noted there at the bottom, you can also include other claims in a conciliation court case if you're filing for a privacy violation. If there were repair issues going on while you were living under that landlord that were never fixed, you can ask for rent abatement for that. The basis of conciliation court is you just have to be claiming that the opposing party owes you money. And there is a monetary limit to conciliation court, which is $20,000. There is a filing fee for both a rent escrow and a conciliation court case. It's around $80. The actual amount would vary depending on what county you're filing in. If the tenant is low income enough, they can get a fee waiver and not have to pay anything to file the case. But if the tenant does have to pay the filing fee and wins the case, they can get that filing fee back from the landlord as well. Okay, and then the rent escrow option for those tenants who are still a tenant at the time they file of the landlord who violated their privacy. Again, they can file in conciliation court, but I would recommend the rent escrow just because it's a lot faster. It can take 3 to 6 months right now to get a hearing in conciliation court, whereas in a rent escrow, tenants are supposed to get a hearing within 2 weeks of filing the case. So it's a faster process typically. There is a little bit more, there's a preliminary step you have to take to file a rent escrow that you don't have to take for conciliation court. For conciliation court, you can just go ahead and file. There's nothing you need to do beforehand. But in a rent escrow, the tenant first needs to give the landlord written notice of the privacy violation and then wait 14 days. Once the 14 days have passed, assuming the landlord and tenant haven't come to some sort of agreement to compensate the tenant for the privacy violation, then the tenant can file the rent escrow. This might sound a little bit odd, and that's because it kind of is. Rent escrows historically were used for repair issues. They were filed to force landlords to make repairs, which in that context, the notice and waiting 14 days makes a little bit more sense. Tenants had to give their landlord, and still do, have to give their landlord written notice of the repair issue and then give them 14 days to fix it. If it's not fixed after those 14 days, then they can file. This is a little bit odd in the context of a privacy violation because there's nothing really for the landlord to fix once they send their written notice. So it's kind of it's a preliminary step you have to take just because it's required for a rent escrow filing for any rent escrow. Tenants have to give written notice and then wait 14 days. Because rent escrows have historically been filed for repair issues, and at one point you couldn't file a rent escrow for a privacy violation, tenants should be prepared to explain to the court why it's proper to file a rent escrow for a privacy violation. You've been able to file rent escrows for privacy issues for a while now, so I don't imagine this is coming up much anymore, but it used to. When it was pretty new that tenants could file rent escrows for privacy, some tenants got their cases dismissed because the court just didn't know that this was the proper procedure for that. Tenants can do this just by pointing to subdivision 6 of the statute, which explicitly states that tenants can follow rent escrow procedures to enforce the privacy law.
Yeah, and as someone who has been doing this for a while, I've seen those cases where the tenants get their claims dismissed. In certain places, like you might, as an attorney representing the tenant, or as a tenant representing yourself, you might be in front of a judge who has never had a rent escrow before. They are becoming more common, but they're still not the most common case. And so it is, every judge is going to have their first rent escrow. They might think this is supposed to be about repairs and privacy. And so hopefully it won't happen, as Maya said, as rent escrows become open to more things. And this has been a while now for privacy specifically. Hopefully it's not that big of a deal. But people representing tenants should be prepared to argue that you know, this is an appropriate place. They're following state law. They can file a rent escrow for this. That you don't want the case dismissed because of it.
And one last little difference between filing a rent escrow versus filing in conciliation court for a privacy violation is that in a rent escrow, the tenant does have to pay any rent that is due to the court rather than the landlord when they go to file the case. Obviously, that's not a thing in conciliation court. Tenants sometimes get confused about what they have to pay to the court and when in a rent escrow. So, just for a quick example, let's say the tenant pays rent on the first of the month and you go to file a rent escrow today. If you've already paid rent for February on the first to your landlord, then you won't have to pay anything when you file the case. But then when March rent comes due on March 1st, that rent the tenant will pay to the court rather than the landlord, and any subsequent month's rent as well until a decision is made and the case is closed.
We have a good question here related to this 14 days,
Mhm.
which is, would the tenant and landlord be able to come to an agreement within that 14 days? For example, if it is for a privacy violation, the tenant is willing to take 400 to not file. Would this be allowed?
Yeah, I think although the written notice thing does seem a little bit odd in the privacy violation context, I think it actually does give a good opportunity to try and settle out of court. Most people don't want to go to court. It's nobody's, maybe unless you're an attorney, it's nobody's dream to have to go to court and do all of that. And if your landlord, speaking from a tenant's perspective, if a landlord is willing to give you the $500 or terminate your lease early, if they're willing to give you everything that you want out of a court case, then take it. I think it's a good way to just kind of open up settlement negotiations to see if you can come to an agreement before resorting to legal action. And some landlords may be willing to do that just to avoid the whole court process. The only thing I would add to that is if it's your landlord agrees to terminate your lease early, get that agreement in writing. You don't necessarily want to take their word for it. But yeah, you can definitely use that written notice in those 14 days to try and settle out of court.
Yeah. And, to the question of, like, would it be okay to take 400? Yes, certainly if the tenant and landlord both agreed, you could accept less. And there are multiple reasons for everyone to agree to that. The tenant doesn't have to go to court. They don't have to go through all that work. So often, just accepting a little bit less to avoid the effort is worthwhile. Another question here, which I'll answer, is would a settlement be considered a waiver of the privacy right? So I assume that what this is asking about is, the statute says um, you can't waive the requirements of 504B.211. The short answer is I don't have a case to cite for this proposition, but all I can tell you is settlements are treated differently. Like there are many statutes in landlord tenant law and outside of landlord tenant law that say you can't waive the rights in the statute. For example, security deposits. Landlords can't waive the 21-day requirement for security deposits. People settle court cases all the time. They settle court cases for any number of different reasons, and those settlements often do not cover like the very specific things that the statute says a tenant can get. For example, in the landlord tenant case, they don't get the 500, they don't get the doubling penalty under 178, et cetera. Settlements in court cases are just treated differently, and there probably is a cite to this somewhere. I've never had to use it. Judges, et cetera, all just sort of accept, if you can't waive it as a settlement in a court case, then you would just be prohibiting settlements entirely in court cases. So settlements to end court cases, settle court cases even before they start, would work.
Yeah. And just one last thing to add about filing a rent escrow for privacy while you're still living there and while the tenant is still a tenant. Tenants can absolutely do that. We just talked about it. It's definitely a possibility. However, if a tenant wants to sue specifically for the monetary penalties, and that's their main focus, I will often recommend that tenants wait until they move out to sue the landlord, which in that case, they'll have to do it in conciliation court just to avoid straining the landlord-tenant relationship while the lease is still ongoing. Nobody likes being sued. Landlords don't like being sued. Neither do tenants. And there is always some risk that the landlord finds damages to deduct from the security deposit. Obviously, if you're looking to have your lease terminated early, then you want to just go ahead and file. But if a tenant is specifically like, I just want this $500 penalty, I will often recommend waiting until they move out if that's at all possible. Obviously, if they really need the money right away, or they just have no plans to move out anytime soon, then that may not be an option. But if a tenant's planning to move out in a few months anyway, I will often recommend that they just wait because then also you can file one case for the privacy violation and the security deposit if there becomes issues with that. There's a 2-year statute of limitations to get the penalties that are authorized by the privacy statute. So tenants have 2 years to sue for the privacy violation and be able to get those penalties. Oops. So now we've talked about what procedure to use for a privacy violation. Now we're just going to talk a little bit about how you go about proving a privacy violation in court. It can be a little bit difficult, and it really takes a case-by-case analysis looking at the whole situation that led up to the privacy violation and what part of the statute was actually violated. Usually tenants are looking to file a case over a privacy violation where the landlord didn't give proper notice. I think, and Samuel, you can correct me if I'm wrong, I think it's a little less common for tenants to challenge the reasonable business purpose, but it does happen. So first and foremost, when you're thinking about proving this, the burden of proving that there was a privacy violation is going to fall on the tenant. They have that burden of proof. The easiest scenarios to prove are where the landlord doesn't give any notice or gives less than 24 hours notice, and the landlord enters while the tenant's home, or if the tenant isn't home, the tenant has a security camera in their unit. In either of those situations, the tenant can file the lawsuit, either show the video footage to show the landlord entered and when, or the tenant can testify as to when the landlord entered and when if they were home. Then the tenant can tell the court that the landlord didn't give any notice or show an improper notice. It's basically impossible to prove that somebody didn't do something. So usually tenants just have to state that if it's a situation where no notice was given, they just have to tell the court that no notice was given. And then at that point, it would be up to the landlord to prove that they did give proper notice if they wanted to argue that. And if that's true, the landlord should be able to show proof of the notice.
And just to respond to what you said earlier, yeah, I mean, generally the privacy violations that I see are number one, the landlord giving short or no notice, or in very rare cases, the landlord not having a reasonable business purpose and like entering for reasons that they should not be there. But that's pretty uncommon. Most of the time, it's what you said. It's the landlord does have a reasonable business purpose to be there. Repairs are the most common reason, but they have not given notice before they enter, or they gave short notice. And so, how you prove that is exactly what you said. You have videos, you have, frankly, a lot of times the landlord just admits to it because, again, they are coming in for a reason. So they're saying, I have a right to be here or something like that. But tenants often have cameras. I just last month saw a tenant have a picture of the landlord entering the house without notice because they had a camera set up, and the landlord came in with zero notice. The tenant had it on camera, so like that is also becoming more and more common of a way to prove it in our current era.
Yeah. And proof gets a little bit trickier when either the tenant doesn't have a video camera in their unit or the tenant isn't home when the landlord enters unlawfully. If the tenant isn't home when the landlord comes and they don't have a video camera, a lot of times the tenant doesn't even know that it happened. If the tenant does know about it, it can be difficult to prove that unless the landlord will admit it, that the landlord actually did enter. And filing a lawsuit becomes a little bit more of a he said, she said situation in that scenario. In these situations, I tell tenants to try and get the landlord to say in writing that they entered the unit. Doesn't have to be writing. Writing's always best. They can email the landlord, say they noticed things were moved, if that's true, or say it just seems like someone has been here. And if you can get the landlord to say that they did enter and they didn't give notice, that can be enough to prove that privacy was violated.
That is, just to add in, that is one of the difficult ones. If the tenant is not there and they don't have a video of it and the landlord isn't admitting to it, or is saying it wasn't them, then that is probably not a case I would recommend the tenant file without more evidence. And so often the evidence or the advice at that point is you got to get a camera. You got to put a camera up. It's not that expensive anymore. Frankly, you can get like full on 24/7 recording with a very lot of backup for about $30 or less, depending upon what you go for. So it still costs money, but it is affordable for most people to buy one camera and set it up. And that, if you suspect that your landlord is coming in frequently, is I think the next step. If you can't admit it, if they won't admit it, if you weren't there, you didn't see it, something like that.
Yeah. If the landlord doesn't admit it, you don't have a video camera as a tenant or something like that, tenant wasn't home. The other thing that could help is maybe you have a neighbor testify if they saw the landlord enter at a certain time, they witnessed it, that could be used in court. But like Samuel said, when you don't have really any concrete evidence and it's really just saying, I think the landlord entered here, I don't have any proof to back that up, it's probably not worth filing a lawsuit over. But again, proving privacy violations really is a case by case analysis. It takes that. So if you have specific questions about situations that we didn't talk about here, specifically proving privacy violations, you can call or email the hotline, drop questions in the chat now, whatever works best. And then I'm just going to quickly go over some example cases where the privacy law has been litigated. The first case is Tavi Ryan Rentals. This case started as a rent escrow. The landlord and tenant had signed a year-long lease. 4 months into that lease, the tenant asked for the landlord's permission to sublet the unit, and the landlord refused. After that, the property manager showed up at the tenant's door, knocked aggressively. The property manager didn't actually enter. The tenant met him at the door. They had an argument. And then the tenant, after that interaction, sent an email saying she would be out of the apartment on September 1st or as soon as possible because the property manager's behavior scared her. Despite that statement, the tenant continued to pay rent and did not actually move out. On September 3rd, 2 days after the tenant said that they would be moving out, the property manager entered the tenant's unit by breaking the lock. They broke in the door and did not give the tenant any notice of the entry. The landlord argued that they didn't need to give the notice because they thought the tenant had moved out based on her email. The court did not like that argument and said that notice still needed to be given, even if they had reasonably thought that the tenant had moved out. But even so, it wasn't reasonable for them to think the tenant had moved out because she kept paying rent and they did not have any knowledge beforehand that the tenant had actually moved out all of her belongings. The district court found that the landlord had committed substantial violations. Again, this is the older version of the statute. This case is from 2020, 2021. They found that the landlord substantially violated subdivision 2 by not giving the tenant any notice. And they terminated the tenant's lease early, awarded her the $100 civil penalty for the time that the landlord entered and broke the lock. They ordered return of her security deposit, and they awarded her $3,000 in attorney's fees. Notably, yes, this case is under the older version of the statute. The tenant got attorney's fees because of her lease, not because that was included as a penalty in the statute at the time. Ryan Rentals, the landlord, appealed that case, arguing that that they did not substantially violate subdivision 2. Ryan Rentals basically interpreted substantially violated as really badly violated. They basically were arguing over a substantial violation versus substantially violated. The Court of Appeals decided that nothing in the privacy law suggested that the legislator meant to authorize penalties only for really bad violations of the law. In fact, they decided that even technical minor violations were intended to subject landlords to the penalties. The Court of Appeals affirmed the judgment for the tenant, and after the tenant motioned for additional court costs and attorney's fees that came about because of the appeal, the tenant was ultimately awarded over $25,000. So that was a pretty big judgment in the tenant's favor.
And I want to point out that because I think you said this, but that was almost entirely attorney's fees. Like I think the
Yes.
tenant
Yeah.
themselves, I mean, they got the lease rescinded, which has a significant amount of value.
Hmm.
And then they got rent and the penalty, but the penalty was only $100 at that point. So I think the tenant ended up with something like only like 2 to 3 thousand, maybe you know the exact number, 2 to 3 thousand in like damages that went to them, plus whatever
Yeah.
value getting the lease terminated early had.
Hmm.
And so that was 17,000 plus 20,000 plus dollars that the landlord paid to the attorneys, which is, one of the big hammers for these cases if they go to court.
Yeah. The attorney's fees were definitely the vast majority of that $25,000 award, but I think Samuel's right. The tenant themselves still got between $2,000 and $3,000 themselves, which is, I mean, still more than just the $100 penalty. So that was the first case. The second one, I apologize in advance. I'm going to butcher these names. I did some Googling, could not figure out how to pronounce them. Gebrawet v. Nine. In this case, the tenant filed a lawsuit in conciliation court for a landlord's numerous violations of the privacy law. The tenants testified at trial that the landlord came almost every single day without giving any notice, and they estimated that there had been over 100 violations since they moved in. There was also a particularly disturbing incident in this case where the landlord entered without notice, went into the bedroom, and one of the tenants was asleep in the bed and woke up to find the landlord and another man that was with the landlord standing within feet of her. Like that's how she woke up. And in that situation, the landlord refused to leave when the tenant told him to. So the district court decided in favor of the tenant in that case. They awarded $3,300 in penalties for the numerous privacy violations. The landlord appealed that case, arguing that the district court abused its discretion in awarding the tenant $3,300 in penalties. They argued that they should only be able to award $100 per violation that they could actually identify as a separate and prove these separate instances, and that they couldn't prove enough separate instances to add up to $3,300. The Court of Appeals ended up affirming this judgment as to the privacy violation claim. There were other claims unrelated to privacy that were reversed, but the privacy claim was affirmed. The district court had already explained in their judgment that $1,000 of the award is based on the landlord's multiple violations. They decided that the tenant had proved at least 10 substantial violations of subdivision 2, which is so they awarded $100 per those 10 violations. But they noted that it actually seemed like there had been more than 10, that they had proved more than 10, but they just awarded penalties for 10 substantial violations. The rest of the award, the rest of the $2,300, the district court awarded that as a penalty specifically for the bedroom incident because they found that situation to be particularly egregious and warranting additional penalties than just the $100 per violation. So that $2,300 for the bedroom incident was $1,100 in rent reduction. So they got a full month of rent abatement for that. Recovery of their $1,100 security deposit and another $100 penalty, civil penalty for the bedroom incident. The Court of Appeals found that the record and the statute supported the $3,300 award and that the district court had not abused its discretion in that case. And so they affirmed for the tenants. And this last case is Endosi v. Snyder. It's actually one of Samuel's cases. I don't know if you want to talk
Yeah,
about this or you want me to
no,
give
I
a
would
blip.
I would love to. So this is I said it was one of my cases. I was the attorney that represented the tenant. Um, I mean, very briefly, because we're getting to the end of our time here, the landlord was going in to do repairs. And the landlord was not giving notice before going in. And the tenant told the landlord, hey, I don't like this. I know you're coming in because I asked for a repair, but I want notice before you enter. And the landlord kept doing it. And so the tenant, with me representing them, sued the landlord in a rent escrow. There were 7 or 6 violations that the judge felt the tenant proved. And so they awarded the tenant $600 for the violation, but they also fully rescinded the lease. They gave the tenant the security deposit back because, again, the privacy violations made the tenant feel so insecure in their housing, so unsafe that they wanted to terminate the lease. And this is very common with privacy violations. It's part of why it was in the original statute, one of the specific things listed. And so the just terminated the lease, gave the rent back, gave the security deposit back, just like in the case Maya was talking about, and gave penalties for the violation. And basically, said the court, just going to read this from the memorandum, that the court makes such a large award in favor of the plaintiff because of defendant's flippant attitude to the requirements of Minnesota Statute 504B.211, which are exceptionally clear and have been the law since at least 1995 when they were codified as Minnesota Statute 504B.183. Further, the violations continued even after the tenant raised the issue with the landlord. Because this is not a new law and because the landlord appears without any concern that he has violated it, the court finds that these penalties under Minnesota Statute 504B.211 subdivision 6 are appropriate. So again, just going back to what we talked about earlier, you know, sometimes if the violations are not super significant or there aren't that many, the court will just award the penalties, the 500, et cetera. But when there are many violations, when there are serious violations, when the landlord seems to be entirely unwilling to listen to the tenant, to give proper notice, that type of thing, the courts, all three of these cases, full recession of the lease, full return of the deposit, full rent back in the month, and penalties for penalties for the actual violation, attorney's fees in one of the cases, the judge will go after the landlord for serious violations. They don't like it.
Thank you. I know we're running out of time here, so I'm just going to quickly cover. These are some common questions we get on the hotline that are definitely related to privacy, but they are not really answered by landlord tenant law necessarily, or at least the privacy violation statute that we're the privacy statute that we're talking about. This one we get a lot. Can the landlord touch or move my personal belongings? The answer to this varies depending on what the reasonable business purpose is, what the circumstances are leading to the entry. If your landlord needs to move a piece of furniture in order to conduct a repair, that's probably fine, almost certainly okay. However, if the landlord entered to do a repair in the tenant's kitchen and then goes rummaging around in the tenant's bedroom drawers, that is almost certainly a privacy violation because it exceeds the scope of the reasonable business purpose. Notably, if there's no harm by the landlord exceeding the scope of the reasonable business purpose, I don't have a cite for this, but it does seem like the courts are less inclined to award maybe not the $500 penalty, but all of those penalties where there was no harm to the tenant. So that's one thing to note. Kind of related to that, can the landlord record or take pictures of the unit and my personal belongings? The short answer is yes. The landlord can take pictures and videos of the unit so long as it aligns with the reasonable business purpose that they entered for. Now, what the landlord uses those pictures for is a more complicated issue. If the landlord's taking pictures to show that there's a breach of lease to use in an eviction case or to prove that a repair has been made for a rent escrow, that's almost certainly fine and okay. However, if the landlord's taking pictures of the unit to post online in an ad for rent and it pictures your own personal property, that could be a violation of law. Not landlord-tenant law. There's nothing in Minnesota's landlord-tenant law that specifically addresses this situation or prohibits it. But the tenant might have a tort claim for intrusion upon seclusion or publishing the tenant's private information. Homeline is only able to advise on landlord-tenant law. So if you are looking to pursue this type of lawsuit, we would recommend contacting a private attorney. But again, also considering whether taking those pictures and videos aligns with a reasonable business purpose. If landlord entered to do a repair in the kitchen, I don't know why it would make sense for the landlord to take pictures of the tenant's bedroom. But if they entered to take pictures to show to a prospective tenant, then taking pictures of the unit could be reasonable. As a best business practice, if landlords need to take pictures of a unit for some reason, they should do their absolute best to avoid photographing or videoing the tenant's personal property. But there isn't anything in landlord-tenant law in Minnesota that directly addresses this issue. And three, can the landlord talk about me to other people? Again, nothing in Minnesota's landlord tenant law that prohibits this type of sharing of information by a landlord. But certain types of information, like social security numbers, would be protected by other laws. And some landlords, specifically ones who are maybe landlords of a government housing agency property, they might have additional rules that apply to them as far as sharing tenant information. Outside of that, same type of deal as the last question. There could be tort claims, like I discussed earlier, for intrusion upon seclusion and publication of private files. And this last one, again, nothing in landlord tenant law that addresses this issue. But again, dealing with ICE is, with everything going on right now in Minnesota and the fact that it's certainly on people's minds, it seems a little bit wrong not to mention it. Landlords are generally not generally, they are not allowed to let ICE into your unit. I can't think of a single reasonable business purpose a landlord would have for letting ICE into a tenant's unit. So it's almost certainly going to be a violation of the privacy law if that happens, and you can sue the landlord. You cannot sue ICE because the statute only penalizes landlords, but you can hold your landlord accountable for that. If you're
And just to clarify, the can't sue ICE under the statute that we have. There might be ways to sue ICE outside of landlord tenant law, but the landlord tenant law doesn't cover that.
Yes, yeah. And then lastly, I just want to reiterate some information. It's pretty widespread right now, but for the tenants, you do not need to let ICE into your home without them showing you a warrant that's signed by a judge. You don't even need to open your door if ICE were to show up at your door. ICE is reportedly showing people documents and calling them warrants, but unless it is a warrant issued by a court and signed by a judge, tenants do not need to allow ICE into their home. So I just wanted to throw that quick little blip in there. That is all I had prepared. We can take questions if we have any. I know
Yeah,
we
so
are over
we're at
time.
3:01. So I'm going to answer one question that we got prior to even starting the webinar. That doesn't really relate to the privacy type of violations that we were talking about, but is connected to the concept of privacy generally, and that is, can the tenant put up a camera or can the landlord put up a camera? The short answer is it really depends on where that camera is and what it's looking at, but generally, if there's no prohibition in the lease, tenants are allowed to put up cameras that look into public spaces like the hallway or, if their apartment overlooks the parking lot or something like that, areas where there isn't really an expectation of privacy. Obviously, in apartment complexes, sometimes this means that there's going to be a camera that looks right into another person's door. So long as the purpose of that isn't to harass the other person, it's probably going to be fine. And landlords can also put up cameras that cover the parking lot, the common areas, and those types of things. If people have more questions on their tenants, they can give us a contact about that. And then very quickly, could you just go to the last slide there? And the last thing I want to remind people is that we do have upcoming webinars. We have one about Safe at Home next month. The registration for that should be live, went out, and will go out again next month. And then we have another one coming up in April, which you can't register for that one yet, but there will be more information on how to do so next month. And I think I don't see any other questions, and we are at the end of our time. So with that, thank you so much, Maya, for giving a presentation on this. Thank you so much, everyone, for attending and for all the questions. And we will end it here. Have a good afternoon.
Thank you, everyone.